The mic's back.
Hi, and welcome to everyone to what is the English Show, episode 1 of Beltran Brito live immigration questions and answers and news. My name is Stephanie Matza, Beltran Brito, and to my right is who we call the most tropical attorney ever.
It doesn't translate
I know,
as good as I had hoped. Hi all, we are calling this the English Show. The English Show will be similar to our Spanish show, but in English, but also some different things.
A little bit.
I would say we'll talk more casually. I would say
We are far more casual in English.
We are more casual.
In Spanish, we're like very formal and answer questions.
I don't know if our viewers think we're formal.
We are convinced.
We believe that we're more formal in the Spanish show. So I mean, also we like to have a little bit of fun. I would say we're gonna play it by ear this first episode. Hopefully, we'll get better every single week. Hopefully, and we're gonna be talking different topics, different areas that we're seeing. Obviously, we're gonna talk about news and what we're seeing on cases actively. I think it's actually interesting. And as this show develops, obviously we'll have new ideas and new things we could do. But I think it's time that we really create a lot of content for the English audience.
Our main format. So you guys who may not be used to seeing us, because we usually see our content in Spanish, is we answer questions live. So you can be on YouTube, on Instagram, on Facebook, on LinkedIn. Ask your questions. We will answer them. It's our way of sort of giving back to the public and being able to access you guys. And this is good for anyone who is maybe filing their own case, or maybe, hey, they're right at the beginning of their own case and they don't know what to do and they want to ask them some questions first before they take that plunge to speak with us. So you know a little bit more about us. You can visit us at beltranbrito.com and you can fill out some information there if you ever want a formal consultation, but at least this space is to give you some general knowledge.
That's it. Let's kick off with common question. Breaking news?
Breaking news?
Not really breaking. There's no breaking. We're still in a government.
Well, hold on. Yes. Okay.
We're still in a government shutdown. And the reality is that USCIS is not affected by the shutdown. Maybe, on the peripheral, maybe to some degree. For example, Department of Labor is affected. So if you have any processes such as a perm, or you have a prevailing wage that's pending, you're trying to access the system online to see what's going on. There's no movement, and we're not able to file new labor certifications, Stephanie. We're not able to request new prevailing wages until then. So in that regard, if your case is pending, it's just going to continue pending. Wait for it to take a little bit longer, but new cases that are ready to go, unfortunately, we're not able to file it because the system's down. So the government shutdown does affect Department of Labor, is not affecting USCIS.
And it also does not affect Department of State. So Department of State, so issuances of visas at U.S. consulates, issuances of any type of procedure that's immigration related at U.S. consulates and embassies, they are not affected. They're continuing as usual. Surprisingly, consulates are moving relatively fast. That was not the case maybe last year, but right now they are moving relatively fast. And USCIS is self-funded, right? So you always send fees when you're sending a USCIS case, and that's why they are really not affected by the government shutdown, because they're not funded by the government.
That's it. What else we got news?
I think important to talk H-1B, which we mentioned on our Spanish channel, which was that one little change, or not change, the clarification that I think is going to be helpful for the people, which is if that $100,000 fee that they're going to be applying for H-1B visas for new petitions, that only applies if you're doing a petition through the consulate, which was a really interesting nugget that we found. And if you're applying supposedly for a change of status in the US, let's say, for instance, from student to H-1B, you will not need to pay that $100,000 fee per new H-1B petition. Really, really nice and really good work around.
I mean, and it makes zero sense.
It makes zero
sense. Like I understand the $100,000 fee, even though it's exorbitant, and I get it. I understand, but it should be both equal.
Right.
It really should be both equal, because a workaround could be, okay, I get maybe a different type of visa. Maybe I'm here on a student visa. Maybe I'm here as a tourist. I'm able to file an H-1B during the proper time period. potentially you're able to stay in the US and file a change of status in the US. I would imagine mainly it's going to be the student visa format. They're coming to study a degree here. I really think, Stephanie, that the reason they created that and they put that policy in place to only affect consular versus the ones that are here, I really think it's meant to benefit people that graduate from US universities, that are coming off of OPT, and then they're able to file an H-1B, and employers are obviously able to use people that have degrees from the United States. That's a benefit to universities. It's a benefit to employers here. It's a benefit to foreign nationals, clearly. So I think that played a part in that, a little bit of relief for universities, I think. Because the reality is this: if they're like, no, then people are like, why would I study a degree in the United States if I'm not able to get an H-1B in the future? So even though it kind of doesn't make sense, it does make sense. Like, yeah, if that's the reason, if they say it, then I'm like, hey, that's a great reason to do it like that. But what you're also going to find is a ton of people that are outside the US that say, okay, let me get a student visa, and I'll come to the US and I could set myself up to do a change of status to an H-1B in the future. So I hope that they're not going to change anything regarding the change of status in the US, and they continue with that being a waiver of the $100,000 fee and back to the normal fees. But you never know.
There's two things that confuse me about it, which is one, are not confused, which I want clarification on from USCIS, is one, if the petition is already approved in the United States, when I go get the visa issued because I'm going back home for the holidays, am I going to need to pay that fee? They have not clarified that. And we're assuming no, because technically the petition has been approved, but is the issuance of the H-1B visa going to generate that fee?
Zero clues, nothing.
And then the second thing is, if your idea, obviously, what you're saying makes total sense. But if what you're trying to promote overall in immigration policy is that the individuals are going to go back to their home country, that they're not staying here in a permanent status, right, and just not here permanently in the United States, then you're not really promoting that if you're only allowing for this waiver of the $100,000 if you only remain in the U.S.
I mean, that also
it just
is
does, it
illogical.
goes directly illogically with
Yeah.
what they're saying
Yeah.
and what they want, right?
I agree with you.
So I don't know. It's weird. Let's see. There's also a lot of lawsuits against the H-1B $100,000 fee. They have already been filed. So I have a feeling come January, February, once it's sort of H-1B season that you have to start applying for the lottery, I have a feeling there are going to be a lot of changes. So let's see.
Let's see. You never know. Let's go immigration. You never know.
I mean, not nowadays, right?
You
Things
never
have
know.
changed a lot.
People ask me a ton of questions where previously I could give you a pretty good answer to it. Like, I'm like, yeah, this is, I'm pretty sure that this is what's going to happen. I kind of don't know right now in every regard. Some things are still pretty good. Some results are still, controllable, but you might get a surprise that your favorite visa category gets a $100,000 fee. What do you do with that? Anyways,
wait, okay. You want to jump into just a teaser because we talked about doing a seminar specifically to this.
Yes.
But let's tease it a little bit. H-1B, $100,000 becomes prohibitive and you can't apply for it. What can you do?
Yes. Yeah. My favorite.
It was an easy topic.
My favorite solution is always going to be do an O-1 visa. Not everybody qualifies for an O-1, but people could get on track to potentially qualify in the future for an O-1. So not everybody we speak to is ready to go from day one. The idea is to kind of develop that case over time, giving you the tips and the strategy necessary, depending on your career, depending on what your goals are here in the U.S. Do you want to be a full-time employee? Do you want to be more in a freelance type of capacity, working with multiple employers? So there's different options out there. The O-1 visa is really the only visa. It's really the only game in town.
Right.
Like, what else are we talking about? If there's no H-1B visa, okay, what are we doing? L-1s? No. E-2s? Only if there's a treaty and you got to invest a lot of money and open a business. There's people, hey, I'm a professional. I don't feel like doing that. I just want to go and get a good job. The alternative is jumping into something like a labor certification or a perm, right?
Mm-hmm.
Like that would be the alternative. Not every U.S. employer wants to wait 3.5 years for you to obtain a green card. Okay. And that's the reason they have H-1Bs, for example. So I would say for me, it's the O-1. I thought we were doing the seminar this month, but I see that the month is really fleeting.
That might have been on me.
The month is fleeting.
That might have been on me on programming and calendaring that information. But, we will get you some more information very, very soon.
Can we commit to time
You
frame.
know, it drives me nuts when you make me commit on air.
Let's commit.
drives
Can
me
we commit
nuts.
to a range of time?
It makes me
Can we
crazy.
do sometime
a
between
Wednesday?
the next 2 weeks?
Okay,
Is that
Wednesday.
a Wednesday?
A Wednesday between the next 2 weeks.
We could also slam it in on Tuesday.
Twice?
Yeah.
The English show is going to be every Tuesday, 4 p.m. I don't think we're going to do a second.
Okay,
show.
we'll do Wednesday.
I'll do a Wednesday.
Yeah, we could do a Wednesday.
Because the Spanish show is on Thursday.
Or Friday too.
Or a Friday. We do enjoy Fridays.
Fridays are kind of nice for me too. So I
We
like
do
Fridays. Okay, now let's get down to it. Let's transition to questions / comments.
Okay.
Transition.
I have a couple.
Transition.
Do we have a transition? I don't know that
There's
we have a transition.
The show is
just yet.
too new to have a transition. Sorry. Okay. So live Q&A, ask your questions, get a straight answer or a not so straight answer.
Or a very lengthy answer.
Let's go
Gilberto.
through some nice hellos. Go ahead.
Jim, congratulations. Thank you for doing this for your non-Spanish speakers. I'll have 2 weekly doses of my favorite lawyers from now on, Team Steph. So you have one favorite lawyer and one half favorite lawyer, which is Gil.
Favorite lawyers. He said
I
it
appreciate
clearly.
that.
He
Thank you
said
so
it.
much.
He said it. Melko is with us. Can't wait. Greetings, best of the tropics. Thank you very much, Melko. Cruz dropping the English. Hi to the best lawyers in the world. Thank you. Let's give the like to the show. Party time, best. Thank you, Cruz. Let's slam in. This is a great question. This is a topic of discussion, Iliam. Which of the 3 stages can be paid by the employee in an EB-3 process?
Okay. First stage of the perm process is the prevailing wage. Prevailing wage and that sort of process within immigration and recruitment, and ultimately the presentation finally of the prevailing wage before, the labor certification before Department of Labor. All of that needs to be covered by the employer. That must be covered by the employer because the employer is looking for the perfect candidate. In fact, technically, the client of the attorney is the employer. Now, we're going to go through that entire Department of Labor phase that's going to be paid by the employer. Then we're going to go to phase I-140. I-140, I am still of the opinion that the employer must cover the fees. The only time when I allow the employee to come in and start covering the fees is at I-45 adjustment of status phase, or if you're doing consular processing phase. That's the only time where I think the employee can start covering recruitment, labor certification, perm, everything for Department of Labor and I-140 has to be paid by the employer.
I just think it makes sense that anything that is done by the employer,
right,
which is the
Where
labor
they're the
certification, the perm, and the I-140 petition must be paid by the company. Things like, let's just say this dude, this lady live in a shoe with 13 kids. So the employer is like, dude, I'm not paying for 13 beneficiaries for this adjustment of status application. Okay. So are they required, to cover those expenses? I would say no, an employer is not required to cover that. What do you think?
Well, I love the dude. And you see, this is the informality we were talking about.
Oh, that's right. Yeah, I'm much more informal in English. That is true.
Exactly.
Yeah.
Adjustment of status and consular fees where you're including your family members and where there's an applicant. So you are the applicant. You're no longer a beneficiary. That's precisely when I'm going to go ahead and do that. And we don't know what just happened, but we're hoping that we're working.
I think we're still live.
I think we're still live.
Yeah.
Let's see. So that is the perm process. So thank you, Eliam, for your question. I have a question here from Christina. We're going to do a little bit of Spanglish. So I'm going to answer the question in English. If you guys could put me on camera. I wanted to know if the process for the green card lottery is open. Sorry, I'm translating live. So the green card lottery, great question. The diversity lottery visa, it is not active yet. It typically is active this time of year. Typically, it opens up in October. But I went down the Reddit rabbit hole. I've been talking to consular officers, and essentially what they're saying is as follows. This year, for the first time, they're implementing a $1 fee for those individuals who are applying for the diversity lottery. So it used to be free. Now it is $1. Because it is taking them so much time to implement the payment method for the $1, that is why they are basically delayed in opening the lottery. They say it clearly on their website that they're going to open the lottery, but they are saying it's severely delayed. So we're not expecting lottery opening until at least December, maybe January.
Maybe January.
Yep.
It sounded like January.
It sounded to me like January, but I wanted to be hopeful.
From the posts, man, the Reddit
rabbit hole.
The Reddit rabbit hole.
I really went deep in there.
It's good, man. It's good. Hi, Hilberto. How are you? Thank you for liking. Iliam, good question. I see the database, the Department of Labor website to check prevailing wages is down to the government shutdown. How accurate is that tool to know the prevailing wage? Listen, for me, that tool is really about a range. So that's a range I like to check out, and I like to discuss with the employer beforehand, and I like to give them, a range. I'll just give you an example. It's going to be from 80,000 to 100,000. Okay. Given this, it should be. By the way, prevailing wage could come back and it's 125,000. Okay. It really depends what the requirements were, the job duties, everything you put in there. What was the level of experience required? What type of job is it? There's so many factors that go into that. I would say the most important part of a labor certification is the beginning. As long as you get the beginning correct and you get that range more or less correct, and the employer is willing to pay that amount of money for you, you're generally going to be fine. Okay. The issue really becomes if, it was 60,000 on the database, but then you come back with 125,000, the employer's like, no way. And then you have to kind of start the whole prevailing wage thing again, and you would just wasted, depending, 9 months, 6 months. Interestingly enough, before the shutdown, prevailing wages stuff, we're taking less time than usual, but it could be 9 months. It could be a year to have a prevailing wage back. So, yeah.
Like the tough part is I'm currently in the situation now where we just got back the prevailing wage about 2 months ago, and we finished recruitment, and now I can't file a perm. And if the government does not open up, you have to file ads within a certain amount of time. So that is a very tough situation wherein you might have to just start from scratch again due to government shutdown. Let's see. I have a really nice question here, which is from TA. I am an F1 student close to my graduation and ready to transition to OPT. I wonder which route is better for me, O-1 versus EB-2 NIW. All right, EB-2 NIW, let's talk. I typically want at least a couple of years of experience for an EB-2 NIW. Yes, by law, I only need either a master's degree and 0 years of experience or a bachelor's degree plus 5 years of experience. The 5 years of experience having needed to have happened post-bachelor acquiring, right? So after you acquire your bachelor's degree, 5 years of experience. So I don't like to go, if you got just your master's degree, I don't even like to go straight to EB-2 NIW because I want to show that you have experience in what you're saying you're going to do in the US, right? I can't say you're going to come to the US and make this transformative project or future endeavor, but you have no experience in doing that whatsoever. We actually received recently a denial wherein the person had experience, but because they didn't have experience managerially exactly in what we had said they were going to do, which is odd, right? But they were giving us problem and slack on that. So I want you to have some experience in what you're saying you're going to do as your proposed endeavor. I would prefer we go to an O-1 visa, you get some work experience, and then if you got an O-1 visa, there's also 2 more avenues we can explore, which is an EB-1. I call it the O-1 on steroids. It's very similar to an O-1, but you're just going to make it grander and bigger. And or the perm EB2, EB3, which is the one we're talking about, where the company, if they're very happy with your work, can petition you for permanent residency, right? So definitely go F1 OPT, OPT O1, and then from there, evaluate your permanent residency options.
How about somebody that has, I don't know, approximately 20 years experience? They're here, they have their degree outside the US. They just happen to be here doing a study program. Right. I would say that person. Different. Go EB-2 NIW. It could be very good, as a possibility versus somebody that their degree is a US degree.
Exactly. Ensure if they got an F1 and they got a bachelor's degree, and that's their only bachelor's degree, you can't do the EB-2 NIW, right? Not realistically.
It's a hard no.
It's a very difficult case. Yeah. But if you're going for a second bachelor's or a master's and you have years of experience in your home country, then I'm open to it.
Yep. Sounds good. Okay.
I would say so.
All right. So we got a couple highs for us. Hey, Moises. Hi, dear lawyers. Congrats on the English version of the show. I never miss your shows because you always bring such valuable insights and great positivity, even when USCIS gets tough. Moises, I'm not sure I've been very positive lately, but I'm happy that I'm inspiring you. Neither of us have been very positive lately, but I always still have great positivity and a good, mental state when we're doing what we're doing. We're focused on winning cases always, like that is the goal. That is the focus. And thank you for watching us today. Let's go to, hey, I got an RFE on impact. I have 3 peer-reviewed invitations and media mentions. What's the strongest way to respond? RFE on impact, Steph. EB-2 NIW, impact, endeavor.
Is that what he's referring to?
I think so.
Like national interest?
I think so, national
Probably.
interest. Yeah.
Okay. I have 3 peer review. It's just since he said peer review invitations and media mentions, I was thinking EB-1.
But what's the impact?
Substantial merit, maybe?
How about? Got the 3 categories. Hey, tell us a little bit more about that if you can. Hey, that would be good. Let's talk about EB-2 NIW impact. What are you focusing on?
As far as, okay, so if we're going national interest, man, it's been so hit or miss lately, which is essentially I feel like a lot of these cases are being adjudicated I don't want to say the word improperly, but the idea is that you have to be able to say that you have some sort of national impact, and not necessarily that your project is going to be on a nationwide scale. That's the important part. And that's where I think these officers are kind of messing up, that we have to sort of be more forceful in our arguments, in that you can say that you're going to create an endeavor that's only going to be in Miami, Florida, for instance. I mean, it's very unlikely that you're going to create a business that's all over the United States. It doesn't work that way, right? It's too large of a country. But that overarching, your general impact can impact sufficiently enough people that you can potentially raise let's say the city as a whole, and that generally can have a national impact overall, or you're influencing a sufficient amount of people that we could say, okay, this is a national impact as far as like job growth and job creation. I do like those arguments. But yeah, I think they're getting hung up on this whole national thing, and no, I don't think anyone realistically is going to have a completely national impact unless you're curing cancer.
Well, look, this is the issue. Who has national impact?
Right.
I mean, very few
curing cancer.
Very few people do, and very few cases that are approved have that. I would say, and excuse me, I got EB-1 on the brain. Danisar was very clear on the fact that it technically does not have to be national. It could have a regional impact directly, and still be considered to have an impact, a potential impact for the rest of the United States. So I'm of the opinion that even if the impact is regional in nature, it's still beneficial to the case, and you could still argue it. And we've seen it. It's understood that if you're an entrepreneur, you open up your own business, you're benefiting yourself. You might be benefiting your community. Maybe you're benefiting your city. You might even be benefiting your state. Okay. Are you really benefiting other states? Like,
that's the thing, that's why I think it's being adjudicated incorrectly.
Yeah.
Right. That's why I think so. And I think it's very important to say that in your arguments, which is essentially, hey, listen, I have a sufficient impact on this. You know what I love? Like underserved areas. I'm not going to work in Miami. I'm going to work in the suburbs, and I'm going to create sufficient impact.
You mean Hialeah?
Pretty much, but I don't think so. Hialeah is like one of the biggest cities in the US, crazily enough. But no, like I'm going to work in suburbs, or I'm going to work in very rural areas. And so that's an argument to say, hey, listen, I'm going to have a national impact because I'm going to be able to grow or help grow this local economy that will ultimately benefit the state. And ultimately, like it can't be that attenuated, but we also have to sort of fight back with these officers that are not getting that.
I hear you.
By the way, he was talking about EB-1.
Oh,
I'm just saying, I know how to read my people.
Hey, let's be honest. You didn't know. You didn't.
I mean, I just assume he said peer reviewed.
Okay. I mean, you could have peer reviewed and freaking EB-2 NIW.
That's fair. But okay, so let's go into it. So he got an RFE on substantial merit.
A little bit of a different situation.
Right. You want to take it?
Yeah, sure. We've seen now EB-1s with 5 categories approved. 6 categories approved, 4, 3, a ton, and they deny the case because they say, what's the overall impact? Like you say, what is really the overall benefit? because of Kazarian and having that 2 stages of analysis, first 3 out of 10, then substantial merit over. I think of substantial merit like in totality. Okay, this is substantial merit. Even though you've argued it throughout the entire petition, I feel substantial merit, you need to really start hitting it again and hitting all the highlights. Substantial merit at the end of the day, Stephanie, is the biography on why you have extraordinary ability compared to others in the field. And I think it's also important that when you're delineating all the EB-1 categories and definitely highlighting it in the final merits determination, you need to go in and say, I'll just give you an example. Awards. Okay, not just awards. Why is this important? Why were you selected? What? Because of your extraordinary ability. Why were you selected to this membership category of the Grammys that require you to have X amount of registered songs to be considered for a Grammy membership? It's because you have extraordinary ability. But it's not just us saying it. Ideally, you have something to back it up as well. So it's important that an EB-1 is not done just with letters. Okay, letters are fine. It's nice to give context to things, but there needs to be evidence. There needs to be press articles. There needs to be things online written about you. There needs to be other, you're speaking at a conference. I see your peer review. Let's use the peer review. Fantastic. I would probably get a letter from, the editorial board of the publication, and they're going to talk about the fact that you were selected is because of your extraordinary ability and talk about the criteria very specifically. I know it's a final merits determination, but at the end of the day, why not? Like, I would slam it all in there again. I would even argue that the final merits determination has to really be a mini case within itself nowadays.
There's also 2 important buzzwords when it comes to substantial merit that it's important to know. One is national acclaim, national or international acclaim. And the second one is sustained acclaim. So when you're doing your final merits determination, those are 2 very important buzzwords for immigration. I want to show that this is a national or international reach. Therefore, so I'm going to highlight when I'm going back and I'm doing this conclusion, that basically what Gil's talking about, where I'm going over everything that has been submitted, I want you to specifically highlight the things that are national, that, hey, I did this on a national level, or, hey, I actually I'm originally from Argentina and I did this project in Colombia, right? So I'm showing an international perspective. Very much highlight that when you're at the last point. And then the second thing that's very important for substantial merit is that you want to show sustained acclaim. That by law is very important. So I want to show that I've been doing this for a minute, that I've been doing this for a long time. For instance, if you've only if all of your accolades are over the past only year or 2 years, that might be an option. That might be an issue. However, that being said, if I can show and I can highlight, hey, listen, I got this peer review document in 2010, and then I did this panel in 2015, and then I was on the judges panel in 2018, and then I was on a press article in 2021, and I did this other press thing in 2025. That shows continuity over a sustained period of time, and that's what immigration is looking for. So make sure you hit those 2 buzzwords in substantial merits. That is very important.
I'm sorry, I was having technical difficulties.
Do you want me to go on so you can deal with your
No.
technical
I was trying to figure out this thing. We got a whole thing happening here behind the scenes today. So people are telling me we got the vertical going on. We got this thing. We got this happening over here. I don't know what's happening. All right.
I wonder if we're able to read the comments on when we're on the vertical. I think you guys will have to tell us that.
Yeah.
If the comments we're seeing are both on the vertical and the horizontal layout.
But going back to the EB-1 really quick, you made an exceptional point, which is sustained. Mm-hmm. Like, it's obvious. Like, that's why we go ahead. Don't worry about it. Yeah. That's why we go ahead and if you see annoyed, for example, come in for a case, it's just going to be, generally speaking, on actually, they might hit you substantial merit and sustained and sustained. I feel noids are a little bit heavy on sustained, but still, you have to get the final merits determination. Yeah. And you have to win it. So to anybody that's seeing a different set of comments for us, sorry.
Let us know.
Thank you.
Let us know where we are seeing our comments, because
thank you.
We could have sworn we saw everything.
All right, let me get back here. Let me grab something. So we're trying this vertical thing today. So like we're trying the vertical. We don't get the shots of us.
We tried so many things too. We tried so many new things. We were like the English show, the vertical. Let's try it all.
Yeah. I mean, we're actually, this is a pants optional show right now. And it's
not for me.
It's a pants optional show. That means obviously what you think it means. I feel that maybe the Spanish show is funnier. Maybe me and you are funnier in Spanish than English.
I tell a lot of jokes in English. So honestly, I think I'm hilarious in English.
You mean the dad jokes?
Yeah.
Nah.
I have so many jokes.
I know, but you're not hilarious.
I'm hilarious.
No, it's okay.
Everyone thinks I am. And I too agree.
I've been practicing English with you. Thank you, Jean. Hi, Troppy Lawyers. Excellent program. I've been practicing English with. Thank you. How true is that 90% of the cases sent to EB-1 visas are requesting RFE?
90% is a wild number.
No. Listen, higher than normal, I would say is accurate. Higher than normal. Normal being not that frequent for me. I'm talking about me, Gil Brito. Stephanie Matza is going to have her own individual situation. But I'm just saying, for my personal cases, it's a tick above, more. I'm seeing it, but not a crazy amount. I'm not talking about 90%. I'll be honest with you. If 90% of my cases received an RFE, I don't know.
I'd be crying a little bit.
We gotta. Well, I wouldn't cry. I think we gotta pack it up. I gotta be like,
oh my God,
I gotta be like, let's just go do something else. Like,
no.
Let's become bankruptcy attorneys. Like, I don't even know what to tell you. Like 90% is too high. Like that. And by the way, if that's the number, I gotta tell you, if that's the national number and that number is actually coming from somewhere, if it is, let me just tell you, it is not my experience. Like we're seeing a ton of cases being approved without an RFE. Mm-hmm. Yes, we are seeing an uptick in RFEs, especially with. Yeah, I know you hate me to say this, but I'm going to say it.
Don't say it.
Premium processing cases.
That's not my experience.
That's not her experience.
I would like to make that clear.
Allegedly. So I'm just saying, that, the likelihood for my personal cases is a little bit higher than with normal processing. I would say normal processing EB-1 cases, RFE percentage, I doubt it's more than 20%.
I would think so.
Yeah. I would doubt it. I would doubt it. So look, build a good, strong case from the get-go. It's okay to receive an RFE. It's not okay to file weak cases, like I would say. Spend the time necessary to build your case. Make sure it's strong. Make sure you qualify.
Yeah, my experience is different. My experience is I'm not seeing a difference in RFEs in premium versus non-premium. That isn't to say it doesn't happen, right? It does happen. The one I'm seeing is more national differences, like certain nationalities are being treated differently than others. That's what I'm seeing more. And like that, I have concrete evidence to back.
Like what are you thinking?
Yeah, essentially I'm seeing more fees for Venezuelans in particular.
Mm-hmm. How about Colombians though?
Colombians, no, thank God. Don't wish it either.
You think that's coming?
Knock on wood.
I like what Marco Rubio said. He's like, listen, our problem is not the Colombian people. Our problem is their current president. And going to the point of, hey, are normal Colombians living in Colombia going to be affected by everything that's happening in the relationships between the countries? And hopefully not so much. And I really have not experienced that a lot. However, I feel the Colombian media in particular, Stephanie, has been bringing this up to the attention of Colombian nationals. And they've been scaring them. So I do receive that question quite frequently, almost on a daily basis with my Colombian clients. And I could tell you, I could tell you definitely I am not experiencing for one particular nationality that they're just denying cases. It's just not my experience, because if that was the thing, then maybe they would, they'd deny Chinese cases more, or they would deny cases from other countries that we maybe don't have a great relationship with. So it just has not been my experience with my individual cases. Okay. Really quick, you want me to pop off some questions here?
I have one.
Okay, let me go real quick.
May I?
Yeah, I'm just gonna. So what I'm gonna do is I'm just gonna do this.
May I?
I'm gonna
because I had one. I had it teed up.
I'm gonna do this here. I'm gonna do this.
Lightning round? It's not even time for the lightning round.
That's the air horn to keep you in check.
No, I have one.
Yeah. Okay.
Maria asked me a question.
Oh man.
And I was ready to get it, and you're trying to steal that question.
I don't want Maria's
because I know you're trying to steal that question from me.
Listen, let me just get Carlos. I have a J1 visa. May I switch to an NIW? Okay, may I switch to an NIW EB visa? I'm a teacher in a high school. Okay, Carlos, is your J1 subject to a 2-year home residency requirement? look at your visa and also look at the DS 2019 form to see if you are subject to going back home for 2 years after your visa is completed. If you are subject, yes, you may do an EB-2 NIW. You may go ahead and do a EB-1. You could be an EB-3 sponsored with a company. You could do other visas, but you're not able to do it, with the exception of the O-1, without a J-1 waiver being approved. So you not going to be eligible to file a green card application until that J-1 waiver is approved if you're required. If you're not required, we represent many teachers, and I would say by and large, the teachers we represent are required to submit a J-1 waiver. By the way, they're usually approved, but I like to handle that aspect of it first, get that approved before we're talking about EB-2 NIWs and stuff. Now, do you need a J-1 waiver to file an EB-2 NIW? No. You could file an EB-2 NIW, you could file an EB-1, you could file, first couple stages of an EB-3 process. That's fine. What you cannot do without a J-1 waiver is file an adjustment of status application. By the way, including getting married to a United States citizen, okay, without that waiver application. So any adjustment of status, unfortunately, you're going to be having to undertake that, okay? If that's not your situation, yes, you're able to do it. We actually, do a lot of EB-2 NIW for people in the school system in Texas, Alabama, Georgia, Florida as well, okay? So it's possible. If you like, you could be in touch with us. Go ahead, madam.
Thank you. I would add, because we talked about this on the Spanish language show, I think it's interesting. In last year, they removed a lot of countries from the J-1 list that required the 2-year residency requirement.
Excellent point.
So I wanted to go through the English-speaking ones just because that might be helpful here. Primarily, I would say from this type of audience, China no longer needs to have to 2-year residency requirement, which is crazy.
Are you serious?
That surprised me a lot.
That is surprising, yeah.
Guyana, India. Also very surprising.
That's incredible for Indian doctors.
Yep.
Wow.
Indonesia, Malaysia. Obviously there's a lot. I'm just picking and choosing what I think might be the most. South Africans.
Stephanie, this is for every job category. Yeah. This is across the board. That's the
crazy part.
That's crazy. Yeah.
Wow. South Korean, Turkey, UAE, Trinidad, Thailand. So none of those countries, if you have a J-1, and even if your form did originally say that you were subject to the 2-year residency requirement, no longer have it, which is actually impressive.
That's incredible.
Yeah.
Right.
Very different.
Great opportunity.
Alrighty. So I'm going to go with my original question, Maria, which he made me skip. U.S. master's degree in data science, gap denied. Was it denied or you weren't chosen in the lottery? I do want that clarification. Outside the United States, is it NIW possible from abroad, or should I try O-1 first?
Did you flush a toilet or something around there? It kind of sounded like a weird.
I thought you were putting things on the soundboard. I was like, what is that? Okay, Maria, you could definitely do an NIW from abroad. I would do an O-1 first if you want to be in the United States very promptly, right? Because an NIW currently is taking about 2.5 years, including delays with visa bulletin, which is essentially a system. It's a quota system for giving the residency, even if your EB-2 NIW is approved. So regardless if you're looking at that type of petition, you're looking at about 2.5 years abroad without any sort of the ability to live and work in the United States. So you may want to consider the O-1 first or even during your EB-2 NIW, so you can wait out the length of time in the US. And that is considering if you have a US employer that could petition you, particularly for an O-1A in your specific case. But yeah, we could actually go straight to NIW if the time concern is not an issue for you.
You missed the greatest part about Maria's question.
What was it?
Her name.
She's a realtor?
She's a realtor.
She's got a master's in data science. Wait, what?
Hey, man, you got to have a side hustle. Welcome to America.
Oh, my God. I said the word side quest the other day in the marketing, and I was like, oh, no. I've been hanging out with the youth too much.
The youth.
A realtor is tough. Don't do an NIW as a realtor.
Oh, God.
Don't do that.
How about project manager?
No.
Construction. I get those a lot.
That one's fine.
Thanks, Helium from Michigan. Yes.
Michigan, cool.
Welcome to the show.
The second best UM. The first best UM is obviously University of Miami.
I just got a UM license plate. I'm really happy about it.
Did you really?
I did. I used to have a UM license plate for years.
And you didn't? Yeah.
When I went, and then I just literally, as you get cars and stuff, you just kind of like don't do anything. I just got a University of Miami. It's nice. It's black. I really like it. It goes well with my, it's now black. Yeah.
The plaque is black?
It's a plaque.
The plaque is black.
The plaque is black. Okay. Let's go. Okay, interesting, Lizbeth. Hi, asylum closed with USCIS. Okay, TPS 2021 can apply for a student visa. I'm in the EB-3 process. Really important, Lizbeth, to be able to file a change of status to any non-immigrant status. TPS was a non-immigrant status. You had to have prior to the TPS a non-immigrant status. Asylum pending, for example, is not a non-immigrant status that allows you to change and to continue having a non-immigrant status bridge for all of your statuses until you're able to file that F1, work visa, whatever you choose to file. Now, really important point. If during the time that you had TPS, let's say you were, I'm just going to give you an example on time. You entered the US in 2017, you applied for asylum in 2018, TPS came around, you applied for TPS. Now, you went ahead and obtained a TPS travel document and you entered and exited the United States. You obtained a new updated I-94 that probably expired on or about September 2025 when TPS was over for the 2021 group. You are able to file that change of status to F1. If, however, you never traveled since you entered way back in 2017, using my example, 2018, you are not eligible to file a change of status to F1 from TPS because you never maintained non-immigrant status throughout your time in the US. Okay, so that's an important point. So I imagine, Steph, there'll be a lot of people that are filing for these things. Unfortunately, they will be denied if you did not have a status bridge.
Correct.
Okay.
Correct. All right. I have a good question that kind of continues what we were talking about. South Locomotion, if someone has been living in the United States for several years with multiple O-1 approvals, would filing an EB-1 under premium processing be considered risky, or it's the same? What we were saying, essentially, Gil and I are actually having a little bit of different experiences. He's seeing an uptick in RFEs with cases with premium processing. I'm not seeing that as much. Now, what I would say is this. If you recently renewed your O-1 and you have 3 years left, save yourself the money and don't pay the premium, I would say, right? Because without premium, they're giving a response within, I think, officially 15 to 16 months. I've seen it roughly at that average. So you can afford to be able to do the petition because you have your O-1 that's protecting you time-wise. Now, if you have less than a year on your O-1, obviously that's a decision you have to make, whether I pay premium so that I don't have to renew the O-1 once more, or whether I renew the O-1 once more to give me time and then do regular processing. For me, honestly, it's the same. I know there are different experiences where premium may potentially lead a bit more percentage-wise to an RFE, but if you have the time, I would say save the money and don't do premium. Or maybe do an upgrade later based on your time. Like upgrade to premium later.
I've done it all. I don't know. Do you think it's maybe your percentages are a little bit different than mine because of my sheer volume of cases that I file compared to yours?
That was really targeted today.
I
included $20 bill with all my cases. Is that why I think it really pushes me
Do you think
over.
the reason is because I have such more higher volume
No, I don't
of
think that's the
cases
case.
and clients?
Is it that much of a higher volume?
Is it that clients want to work with me more? Is that it?
You're really hitting hard today, are we?
Are we doing it?
All right, we're just getting aggressive today. Is what
Let's
we're doing.
go to congrats on the first episode, Angeline. Thank you very much.
It might be the last if I keep getting treated this way.
She's a member. Don't forget, this is episode 1. The idea with the episodes, by the way, what's going on?
I'm mad at you.
Why are you mad at me?
I'm gonna look this way at this camera, and I'm not looking at you anymore.
Why are you mad at you? You're an exceptional attorney. I'm just saying. Sometimes people want to work with you more than work with me. That happens all the time, doesn't it? Does it not?
I include a couple of bills in my cases.
Listen, I'm not,
which is why maybe my premium is going up.
I'm not for everybody. I'm not. I'm a particular type of flavor. I'm the guy wearing a tropical shirt while you're in a button tied. You know what I'm saying?
That is true.
I'm a different beast. You know what I'm saying? It's like, and I do work a little differently. You know, but no, seriously, all joking aside, if the case is exceptional, I think her name was Locomotion. I don't know.
Locomotion.
Oh, was it Locomotion? Locomotion. If the case is good, I still want to do premium. So that's it. And one thing I constantly try to impart on everybody. Every case is different. Anything we're saying here, listen, we're just talking in generalities. Right. Overall, your case is very individual. You've had multiple O-1s approved. If you've had multiple O-1s approved, I'm all in on a green card. I'm like, hey, we got to go a green card. Like I'm not the attorney to tell you, hey, keep renewing. I hear this all the time, Stephanie. They're like, keep renewing. Oh, Gil, I'm kind of tired because the attorney I'm working with, she says I could only get 1-year extensions on my O-1, and they've been doing it every
so
2
awful.
years. Excuse me, we've done it over the last 3 or 4 years. I've had 4 visa applications because I initially got 3 years, and then she said that was impossible to get extensions. I'm like, no. Okay, no, obviously we need to work on a 3-year extension every single time that we're filing it. That's not saying that you may not obtain less time, but that's saying that the effort has to be there to obtain the 3 years. So if you have the time and you have multiple O1s, we want to get you into a green card. We don't want to be in more O1 extensions. So that may mean doing premium processing. If your case is very good, believe in it, you could do premium processing, and we expect to win. That's why we're doing that. Like any case we file, we're expecting to win. Just that, they were asking the question of 90% of the EB-1 cases are receiving RFEs.
That's crazy. That's such a crazy statistic.
I don't believe it.
I don't believe that at all.
Yeah.
I will say, let me put a notation here. Let me put an asterisk. If you're close to the end of your O1, don't concurrently file an EB-1, please. Extend your O1, because during this administration, I think you just need to be more conservative. I will make that notation.
And again,
if you could avoid it.
That's my advice. That's what both of us agree. That is the way to go. But what you find yourself, and I have one on top of mine right now that I recently did, and they've had multiple O1s, and people are just tired of having.
I get it.
In O1, or obviously economically, not like financially. It's everything's expensive, but aside, they don't want the limiting factor of only being able to work with one employer or in their given field. They want their spouse to be employed. So every case is different.
Correct.
And depending on your personal needs. So I'll take, Steph, in a very good case, normal processing concurrently file.
Yeah.
And I do it. And as long as it's a very good case, and I'm very honest with the clients, and I tell them, listen, there's always a chance that the case is denied. If the case is denied, what do you need to do? You need to depart the U.S. We'll get you another O1. I'll file for a green card while you're outside. But unfortunately, you cannot stay here nowadays. This is a public service announcement to everybody. If you file a case, change of status in the U.S., meaning non-consular, whatever it may be, and that case is denied, if you do not depart the United States in a short period of time, it is likely nowadays more and more, especially what we're seeing in the last few months, that you will be placed in proceedings and you will receive a letter that says you must go before an immigration judge and decide what you want to do with your future here in the US. So this is happening more and more after case denials. So I'm just putting that out there as a feeler because I haven't said this in English language, but we've seen it over the last 60 days, more or less, impacting certain cases and certain people. And it's a scary notion that even if you may be with a case that's pending, Stephanie, they're placing people in proceedings. We've seen it already multiple times. Enough so that I would say that's a pattern, and that's an interpretation of this new administration's, well, it's not, the current administration's law regarding if a case is pending or not. Anyways, we could get more into that later on, but I just throwing that out there that yes, there's consequences to staying past your time in the United States. And obviously the idea is to win cases and do things the best way possible. However, every case is different.
Yep. Okay, this is a fun question, but I'm checking November Visa Bulletin just really quickly before I answer it. So EB-2 was the same for November Visa Bulletin? Do you remember off the top of your head?
Yes, it was.
Okay. All right. This one's a little bit sad, the answer, but it is an interesting question. I have a pending EB-2 NIW with priority date on 7/15/2024 per current Visa Bulletin. Would I be able to adjust status this year in case I am approved currently living in Texas? Blessings. Gustavo, unfortunately not. If the date of your Visa Bulletin, which is highly unlucky, right? If it is your exact date on the Visa Bulletin, you cannot file adjustment of status. The date needs to be prior to. So if you were July 15, 2024, you would be good to go. But because the Visa Bulletin says July 15, 2024, and your priority date is July 15, 2024, you cannot file the adjustment.
Steph, you know what? I'm looking at the Visa Bulletin for November, and EB-2 final action dates December 1st, 23.
But it's dates for filing.
Excuse me.
Yeah. Thank you.
Hold on.
I'm glad you did it to yourself because you usually do that to me.
Sorry. I was wrong.
Oh my God.
I was wrong.
Someone please record that and
I was
send it
wrong.
to me later. Yeah,
Damn,
it was unlucky. I remember
wow, we researched that
we
quite
researched
a
it
bit.
because it happened to us like 2 years ago for the first time because it's just so particularly unlucky.
It's very random.
And
yeah.
we went down and we were like, no. But hey, it'll be fine. Gustavo, what's your current status? You're currently in Texas. What is your current status? That part worries me a little more.
Oh my God, TPS pending.
Oh no. Hope not.
I hope not, Gustavo. Lady says, hello, my dear Troppies. I don't know why I see the live strange. You know, the live's been very strange.
So? Everything has been strange.
Lenny's, the live has been extremely strange. Episode 1 has not come without its hiccups. There were ups and downs.
The only hiccup I see here is you
highs and lows.
You being mean to me on air.
I'm not being mean to you. Okay, a little bit.
Yeah.
Andrea, hola. Oh, look at what you did, Andrea. You almost made me do it. Hi, I have TPS 21 without asylum. Am I eligible for an EB-2 NIW? Can I apply for asylum before or after asylum? Okay. So what was your number one? No. Okay. Did you have a non-immigrant visa status prior to the TPS? If you did, great. Now you have TPS. Wonderful. You continue to have non-immigrant visa status. From there, can you file an EB-2 NIW? Yes, you may. However, that is not going to give you any legal status in the U.S. until there's a visa number available. Like Stephanie just said, it's July 15, 2024. That's what, for the cases filed with that prior to that priority date, are the ones that are able to adjust their status. So what are you going to do before the 7th of November, 2025? I say file a student petition. You know, I don't mean it's going to be easy. You may have to document your country ties, all the, very specific things to go ahead and accomplish it. But I have a ton of TPS people that we've seen been very, I'm not going to say lucky, but have been very fortunate with obtaining F1 statuses. And we've seen other non-immigrant visa categories applicants not be that fortunate coming off of a TPS. Okay. So I would say first do the F1, then do the EB-2 NIW, then wait it out. Maybe you could consider day 1 CPT as an option. Another option is to jump into a work visa or labor certification in the future. Okay. Potentially an O-1. Who knows? Andrea, the sky's the limit.
Oh, I knew Gustavo was going to come with this. I read you like a book.
Hey, did we say it or what?
I read you like a book. Asylum applicants since 2017, also 2021 TPS Venezuela. Gustavo, unless you traveled with a TPS travel permit and re-entered the United States with the TPS travel permit, you cannot file an adjustment of status. Because there was a period of time where you did not have non-immigrant status. You only had lawful presence, which is what you had with the asylum since 2017. So if you did not leave and come back as exclusively TPS, then you cannot file an adjustment of status. What are your options? Either you can depart the United States on November 7th, try and re-enter, let's say with an O-1 visa. We could do a quickie O-1 visa for you so you can come back, and then we file an adjustment of status once the visa bulletin allows it. Or you stay with your asylum and knowing you cannot adjust status, and then that's something that maybe you can use, if the judge ultimately denies the asylum, then that's something, maybe a tool you can use to try and eventually obtain permanent residency. But
yeah, it's just rough to convince people. It's rough to convince people of that stuff. In my experience, most people do not want to leave.
That's why I give them the options, right?
Yeah.
But just know that you can't. I don't want you. What I don't want, and I had this phone call today, actually. I don't want you to pay the $1,440, $1,440 for an adjustment of status thinking you could do it when you can't. That's what I don't want them to do.
Because there's a whole bunch of people out there saying you can do it when obviously you cannot do it.
Right.
Like he cannot file an adjustment of status unless he traveled.
Correct.
Entered on the TPS travel doc, obtained an updated I-94, then maybe, yeah. And still, you might still have, a challenge ahead of yourself.
Oh, you're going to get an RV.
Okay, you're going to get an RV and there's a challenge and everything, but it's arguable. It's reasonable. It is not reasonable to file an adjustment of status application after an approved EB-2 NIW coming off of asylum. I'm sorry. And all the attorneys, if you see, Stephanie, what they sent me like there's, I'm having a consultation or something. I told, let's just call him what he was, the dude. I called the dude and I said, dude, listen, no adjustment of status for you. Dude's like, oh yeah, I'm going to send you the law. So sent me the law. Like I felt I was back in law school with this brief and all the things or whatever. And I'm like, I understand. Listen, I could Google and I could chat GPT anything that I want to prove my point, but I'm letting you know what USCIS and how they're going to adjudicate 99% of the time. You're not able to adjust your status. I'm sorry, you know?
And I'll give you a horror story there just to really freak people out. We saw a case where the person back in, I don't know, maybe 2018 filed the adjustment of status from asylum, was approved, and we kept telling him, remember, it was erroneous. I don't know if you remember this. We told him it was erroneously approved, man. They should not have approved it. Applied for his citizenship 5 years later, denied and retroactively denied that.
So I would not have allowed that individual to apply for citizenship.
Of course not.
Like,
he just called us and told us he did it.
I've had some situations similar to that where I was certain that they should not receive the benefit, but they were approved. I mean, by the way, never lying, always telling the truth. You know what I'm saying? Like being extremely truthful. It's not like you're like, one thing is if you're filing a frivolous case saying that you were in legal status. Another thing is like, here's my I-94, here's all my stuff, whatever. That has happened to us. Those individuals need to be very, very careful because they could re-adjudicate that case if it's USCIS error in the future. Okay. Right. So I would not apply for U.S. citizenship, and where they catch you is when you apply for U.S. citizenship. So unfortunate. Right. It is what it is. The show has
stop being so negative. It was a great show.
The show was okay.
We did phenomenally.
I think I like myself better in Spanish.
Isn't that weird? Even though we both speak English,
my
much
preference,
better.
I like myself. I like how I feel in my own skin.
Your skin would be English.
You know what I'm saying? You would think so, but Spanish is my first language, so I would say no.
Spanish is my first language too.
Yeah.
We both just
People
are better in English.
I like Lenny. She's like, hey, I'm practicing my English. You know what I mean? Like I'm listening to the thing. I'm practicing, you know what I'm saying? You know,
today you learned the word
thank
dude.
You. Dude. We'll talk about the Big Lebowski on another episode. This show is gonna evolve.
Yes.
We're gonna do different things. We're gonna have some fun verticals. I don't know if that's been
people told us it was weird, but we have to reevaluate it. But I kind of like the vertical format, if I'm honest. I like it.
You know what we need to do though for the verticals? We need to be right next to each other.
No, because the vertical is just me, which is really what people want to see.
Debatable. So that's the
English show. Episode number 1.
Thank you guys. Thank you for joining us. Till Thursday.
Till Thursday for Spanish, till Tuesday for English.